All right, well, Law Venture, we have a special and reoccurring guest. I feel like you're a regular at this point, Eric, especially with you having videos on the Law Venture channel. But for people who do not know Erik Scramlin, I'm going to let him introduce himself, and then I'm going to hype him up right after that.
Well, thanks. Great to be back on Law Venture. I know it's been a while since I've had a video, so maybe you can scroll in one of the videos that I did while we're talking. But quick introduction. Name's Erik Scramlin. I spent pretty much my entire career as a prosecutor from about 2010 to 2019. I was in the courtroom pretty regularly. 2018, I was stressed out, and we've talked about this before. I just thought I was stressed out. Turns out I was burnt out to a crisp. And I went to the city attorney's office, bounced around a little bit. It finally led me to where I'm at today, which is I started my own kind of thing. Not sure if it's a business or a practice, a firm. I don't know what it is.
It sounds sketchy. It sounds real sketchy.
It's basically just me. It's a one-man show, and I fell in love with training, so I work with prosecutors and law enforcement, teaching them the law. And I think the topic that we're specifically going to talk about today is the trial strategy that I learned kind of the hard way and had some aha light bulb moments, and that's what I teach currently to the prosecutors that I work with.
So for the people who are new to Law Venture or maybe new to your story, how many trials do you have under your belt?
I always say that I did about 100. It's maybe a couple less, maybe a couple of more. But yeah, I mean, I did so many, you start to kind of lose count. You lose track at some point. And I've tried to like do lists before for like resumes and stuff. And when it gets close to that 100 mark, I start like, okay, I forgot about this one. And okay, does this one count? Because I was just second chair. But it's around 100. I did a lot of trials. If you counted bench trials as well, geez, that number would be like, I don't even want to know what it would be. But I just count the jury trials.
But with that type of like quantity, like that amount of experience, and me knowing you being like inwardly competitive, I feel like every time it's just a little bit better, a little bit better. And maybe there isn't that initial spurt of growth, so to speak, whenever you're first starting out because everything is so new. But I feel like with 100 trials, you're going to be crafting your style and what's most effective for you.
Yeah, it changed a lot over the years. I look back sometimes at some of the early trials and I like cringe at the PowerPoint that I made. And I'm like, man, I can't believe I said that. That was so objectionable. Like, I'm so glad the Court of Appeals didn't catch that. Yeah, it's changed a lot. I developed a strategy from doing mock trial in college and in law school, and that carried me through early on in my career, and then it started to change. And it's kind of funny that what I teach now is based heavily on my experience, but it's got this flavor of a new thing that I've never really tried myself in a trial, but I realized it would work, and I teach it, and then I see the results in the attorneys that I work with when they go do it.
Okay, allow me to hype you up a little bit more before we start talking about this strategy. And honestly, it's a little embarrassing. Eric on Law Venture probably has 3 or 4 videos that are just like you teaching the Law Venture community, but you have the #1 hottest video that Law Venture has on YouTube right now. It's the one fact, one question cross-examination video. And that one is just like scorched earth in the legal YouTube world. So props to you.
Yeah, it's funny. I was at a conference, and when was that? Around like October. And I was talking to a friend of mine because I'm growing to the point where I'm trying to see if I can get some other of my trusted colleagues to kind of join me in this. Mm-hmm. And I told him, I said, get out your phone right now, go to YouTube and just type in cross-examination. And he did. He's like, holy crap, it's you, the #1 video. So I thought that was kind of cool.
My ego every time is like, this man puts out 4 videos and one of them pops as the #1. I'm over here trying to pump out content like it's nothing.
The problem is I'm like Vanilla Ice. I just have kind of a one-hit wonder. I haven't been able to recreate it, and I've been lazy. Like you and I were talking, we're using my platform for my podcast, and like I haven't used it in so long. I had to like re-familiarize myself with the dashboard. That's changed, so I've been slacking big time. Got to make some more videos.
Yeah, you got to blow the dust off the mic a little bit.
Exactly.
We got to keep that advice coming. And so that's part of why I'm forcing Erik to be on this podcast right now, because I do feel like we need to get that content, and this is the only way I can peer pressure him into it.
You should also mention that I really did have to be forced into coming on here tonight because I'm recovering from a funeral from a dear friend known as the Detroit Lions. We're just a couple of days removed from that let me rip your heart out of your chest. Think you're going to the Super Bowl. Just kidding. Oh. But we're here. We're ready to get back to work.
I can still see the dry tears underneath your eyes.
Yes.
And this is more of a therapy session for you than anything. Your
so
wife wanted me to make sure that you were okay. This is like the best we could do for socialization.
Yeah, let's jump back into work and let's do it. Let's go.
Okay. So what's the idea behind the strategy? What's the concept? Just so we can grasp that first.
All right, so we'll get right to the point. The concept here is storytelling. And everyone has been told at some point, if you went to any kind of trial advocacy course, you're always told you win your case by telling a story. But a lot of times they never really teach you how to tell a story, because I've been taught that a million times. And I've tried all kinds of different methods of telling a story with my trial, but kind of what I've been able to develop now actually gives you a method to telling the story, and it's pretty effective from what I've seen so far.
Okay, so walk me through, maybe for the audience watching, what you've seen that you've done or lawyers have done trying to tell a story that doesn't work, if anything comes to mind.
Yeah, so a lot of examples. So a lot of times you think about, okay, I got to tell a story with my case. And that usually happens with your opening statement. You'll get up there and you'll kind of craft a story. You know, I'm not some trial genius. Out of those 100, I had some Detroit Lions moments on some of those trials. We didn't win them all, that's for sure. But you learn from those, what works and what doesn't. And everything from me trying to tell us, if I have a case that the facts aren't so great and the witnesses aren't reliable, if I'm trying to sell to the jury that, my people are reliable. And one case in particular, I had a drug trafficking case where I come up in opening, and the way the laws are in New Mexico is there's no special amount. I have to prove based on circumstantial evidence that this guy possessed the drugs with the intent to distribute it. So I know the defense is going to be, my guy's a drug user. He does not selling it. It's not enough for trafficking. So I'm yelling in opening, this is a case about trafficking. This is not possession. Well, the judge directed out my trafficking count. So now I have to go back up in closing and be like, remember when I said this was a case about trafficking? It turns out it is about possession. And of course you lose all your credibility with the jury, and it was a quick not guilty. So telling stories where you push the envelope too much, you lose your credibility, things that don't make sense, things that the evidence doesn't support, or sometimes you try to get too cute. You come up with a cool theme, and then you get up there and it's like, okay, well, it sounded good when we came up with it. I'm just trying to think of some of the dumb ones that we've had over the years. I'm sure we've had some bad ones, but it sounds cool when you write your theme out, the 1, 2, 3 thing, and then you get up and say it, and it sounds terrible, and defense flips it. So a lot of times it's that, or the other big mistake is lack of clarity. You create a story that's confusing, and you spend most of your time in trial chasing your opponent's arguments instead of focusing on what your case is. And then at the end, especially for a prosecutor, if there's a lack of clarity, defense wins. If you're a defense attorney, you want to create confusion because that goes towards your reasonable doubt.
So I'm curious on this concept of avoiding over-promising and under-delivering, but also finding the right balance to where you're not just coming in with the most bland and basic opening, right? Like you want to paint a pretty clear picture. How do you find that balance? Is it workshopping with your fellow prosecutors? Is it something to where you just kind of figure it out through experience? This works better than something else. What's your thought there?
I've developed a process that doesn't work for everybody, but it's a process that I teach them. I say, first of all, the first thing you got to do, this is if we were taking the trial class right here, step one is always start with your uniform jury instructions. That's what we call them in New Mexico. I think every state's probably got some version of prepared jury instructions that you can anticipate is going to go to your jury. Even if you got to create your own, then create them. Because how are you going to write an opening or come up with a story if you don't even know what your case is? If you're the prosecutor, these are the 5 things I got to prove beyond a reasonable doubt. If you're the defense attorney, You don't want to waste time attacking something that they don't have to prove. You start with your jury instructions, and then you go through your case and you start looking at the facts in the light of, this is what I'm going towards, are these 5 elements. Then it's a refining process, going back, good facts for me, bad facts for me, outlining them until a story starts to develop in your mind. And then we create this process of selling your case to the jury, just like you were selling them a product, just like you were putting something on Amazon, and then tapping into what, I'll explain this when we go you'll probably ask me to go through the story brand idea based on Donald Miller's book, but we're tapping into this algorithm that Donald Miller was able to find, the reason why people are wired into a story, why they stay wired into it, and in his kind of thesis of the book, why people buy stuff. And when I read it, that book, a light bulb went in and said, this is the exact same thing you're doing at a jury trial. If you're the prosecution, you're trying to sell your case to the jury. If you're the defense attorney, you're trying to sell your case. And ultimately, the jury's going to pick which story that they buy and that they believe in. And it's the same thing as selling a product. So I've been able to use some of those lessons that Donald Miller has taught to be able to tap into that with the jury.
What's your natural style in front of the jury? Is it fire, brimstone, appeal to the emotional side, or is it logic? I'm trying to check off boxes in order for things to be short, sweet, and simple.
For me, it's probably a little bit of both, probably more on the logic side. I have learned to be a passionate speaker, but a lot of times I watch some defense attorneys go way overboard here when they go into court. Their clients love it because you're putting on a show. But ultimately, is that stuff really working? A lot of times it's not. So I think it's a balance. You want to be persuasive. Essentially, this is a public speaking thing where you're going up and opening and closing. Even your directs and crosses are all geared towards this performance. So I think it's a little balance of both. You can't be dry and bland, and you want to hit on the facts. But ultimately, I mean, this is controversial when I say this sometimes, but a jury trial, a criminal trial, is not about the truth. Prosecutors have the highest ethical standard. They cannot ethically take a case to trial that they are not convinced beyond a shadow of a doubt that this person has done it. The defense attorney has their job to do. Their job under the Constitution is to represent their client zealously. So the result of that in trial is the best story wins. So you're battling it out that way. And if you're coming in there bland as a prosecutor or a defense attorney, just hitting on elements of a crime, nobody cares about that. They care about the consequences. Oh man, if we don't convict this person, this could be bad for society. Now a prosecutor can't appeal to they can't come in there and appeal to kind of what we call the golden rule. Imagine if it's you or your loved one next time. But through the story, you're able to accomplish that. I'll give you an example. I was working with an attorney that we had. She had a case where a guy shot their neighbor's dog. And she was flipping out before trial because there was some bad facts, police knew somebody, or I can't remember. There was something she was really worried about. And I told her, I said, let's take a step back for a minute. The defendant shot a dog. People in this community care more about that than they do an actual homicide of a person got shot. So I said, you need to appeal to the jurors' emotions on that dog. You need to refer to the dog by his name, Buddy. He's not the dog, he's Buddy. In closing argument, he was murdered. He wasn't shot. And you put a big picture of Buddy up there smiling, and I think the defendant made some terrible quote that probably sank him as well. He made some statement about the only good dog is a dead dog or something terrible like that. So I said, if you get the jury to really hate this person, you're going to win. that you're going to appeal to their emotion there without breaking any of the rules and presenting all the evidence that you have to present. And of course, it was like a 10-minute, guilty verdict. In defense attorneys, it's the same thing. You are just taking the facts for your client, and you're tapping into the jury's emotion. We don't want to convict an innocent person, or wow, we don't have enough reasonable doubt. If you're able to tap into that with the jury, then you can be successful. And it's the same thing in a civil case as well.
Yesterday, I was helping coach a high school mock trial team, and they've come so far. They're absolute rock stars. And they have a criminal case for mock trial, which is kind of brutal because, with such a high burden of proof, there's almost like a slanted it's like the Detroit Lions going against like prime New England, I feel
Yeah.
like, because the defense has so many great facts.
Yeah.
And then I'm listening to their opening statements, I'm listening to the story they're telling, and I can see the natural struggle that ends up happening, which is we're trying to prove X, Y, and Z. So we're going to talk about X, Y, and Z. And it's very boilerplate compared to like the defense, even at the high school level. Man, emotions were pouring out, but it was too much, right? It was like there's that sweet spot that you have to be able to find in order to have that right balance. But part of that, I feel like, has to be either like recording yourself and watching yourself, which is just like nails on a chalkboard for 99% of people, or just getting that feedback from somebody else. Because sometimes just like a certain phrase, the way that phrase comes out, like I know you don't intend it in a certain way, but it just doesn't sound great. Like, I mean, I immediately think of what you're saying about the defendant. He's one quote, right? Like one quote can change the entire case. And so that type of feedback loop, I feel like is super, super valuable. And I'm curious, like, were you able to get that type of feedback loop just internally or with your office, or was it just you had so many trials that you can kind of test some things out and work from here and there?
Yeah, there were times when we were less busy. It's funny because I look back at when I was doing it, like kind of in the heyday, like 2014, 2015, when I was doing trials like crazy. And yeah, we had a couple of experienced attorneys I could go to for feedback. They'd watch, especially early on when I first started, because I came from Michigan to New Mexico. 180 difference from what I'd experienced as a law student in my brief practice in Michigan before I moved here. In a lot of respects, was still the Wild West out here as far as like how everything ran. So I relied a lot on the experienced attorneys to help me adjust. But now, part of the reason why I was able to get my position, which is an advisor, just on a contract basis with the office, just to work with the new attorneys and teach them how to do trials, and I do in-house training, it's because they're in trial constantly. I was at the office today, and they have a brand new attorney. She had one job out of law school, but it was nothing in the court, so she's pretty much a baby attorney in all respects, and she was in a jury trial today with the DA, getting her feet wet and cutting her teeth already, and it's likely she'll probably have some major felony trials coming up within the next couple of months. So when it's happening that quick, like, I think you don't get the feedback, and sometimes you can develop bad habits. But now, at least in my office where I'm working, I can watch them. I'll go to court, I'll watch the trial, give them feedback, and I see that that's helping improve. So if you are in an office where you can do that, that's huge, especially if you have time for a big trial. Like Jared said, record yourself, and you can see things like I just did. Word whiskers. That word whiskers were always a problem for me, and I would pick up my pace and start going too fast when I get excited, and I never noticed it until I recorded myself or someone watching and giving feedback, because that's huge. You always want to get better at this. This is a profession. If you want to be at the top, then you have to constantly work at it.
So let's now talk about the story brand style. Like let's talk about what we are working on.
So you mentioned, I know you did a video on your channel about that, and you can go on YouTube. It's a hot topic. So Donald Miller, we'll give him all the credit in the world here. I first found out about this through my old podcast that you were on a long time ago, the old Dumpster Fire Project. Rest in peace, Dumpster Fire Project. On that podcast, we actually spoke with a copywriter in California, not a copyright attorney, but a copywriter, someone that puts, the text and everything to try to get you to buy stuff. And she said, hey, and she spent the whole episode talking about, hey, have you guys heard about this Donald Miller? I'd never heard of him. That was around COVID when I was diving headfirst into, because I know nothing about business, so I'm reading Gary Vee books and anything I can get my hands on. So she opened my eyes to Donald Miller. I immediately went out and bought the book, and the book is about marketing. If you know Donald Miller, you know what I'm talking about. If you don't know, look up. There's a lot of stuff on him. But long story short, I think he was like a playwright, or he wrote an author, and then he started a business, and he was kind of looking into marketing, and he sees this algorithm of how and why people attach to stories. What makes a good story sell? And he found kind of a cheat code where every successful movie or story always has the exact same elements. There's always a hero, right? And the hero usually has two problems. One is an internal kind of philosophical or moral dilemma. The other one is a real problem. So the example he likes to use is the Hunger Games. So Katniss volunteers as tribute, taking the place for her sister. She's got the very real problem of she's essentially the Lions going up against, the 49ers and has to fight these career tributes, or she could die. And then there's the moral, dilemma of killing people and stuff like that. The hero always has to meet a guide. A guide is someone with credibility. They don't take the hero's spot, but they've been there before. They've been successful. And they usually have character flaws themselves, but they always come in and they become the guide for the hero. And they're able to take the hero and transform them and give them a plan and call them to action. And then the movie ends successfully. And that's essentially the script for almost every movie that does well. If you find yourself watching a movie on a Friday night and you're just not getting into it, odds are it is not following that format. If you are, it's probably following this algorithm. So what Donald Miller was able to do is use that algorithm and kind of teach companies to use that algorithm to tell a story about your product or your business and try to get people to buy what you're selling based on tapping into that. And when I read it, I was like, oh my God, that's what a jury trial is. You got two attorneys fighting it out in the courtroom, and ultimately what it comes down to is which product are you going to buy? Are you going to buy what this attorney's selling or what this attorney's selling? Because they got to pick one. Sometimes it ends in a hung jury, but that's usually, if you're a prosecutor, that's kind of basically considered a loss. So they're kind of buying what the defense was selling in that situation. But I kind of found that, so I started playing around with how could we tap into that story brand idea with a trial. And I kind of started developing some methodology. And then when I started this business, I kind of started teaching it a little bit. And then it started to work with some of the attorneys I was teaching it to. Like, man, I did that and it was great. The jury was out 10 minutes, came back with a guilty verdict. So then I kept adding a little bit more and more. I'm still working on it, still kind of perfecting it, but we can go through kind of the methodology that I walk the attorneys through when we're doing it. But essentially what it gets down to is treating your case like a product that you're trying to sell to the jury, and then tapping into those things that Donald Miller says makes people want to be part of a story. And he uses a lot of good examples.
One of the examples that I always go back to, if for all my nerds out there, Star Wars, you have Luke Skywalker, hero, you have Yoda, who's the guide, and that seems like, in my mind, just like the clear, Luke would never have gotten where he was trying to go without Yoda. Yoda was pivotal, but the entire series is all about Luke, right? It's all about Luke. And so I guess that's my question to you. In the courtroom, who's Luke Skywalker? Who's Yoda?
Well, this is hard for the attorneys out there because, and it's funny, when you study the story brand stuff and you see a lot of these lawyer commercials on TV, it's like, man, lawyers make the worst commercials possible. But a lot of attorneys, they're gonna tell you, and they think that they are the hero of the story. Hire me. I got results. I got experience. I'm the guy you want. And then they do a bunch of crazy stuff on there. So yeah, we're egotistical and narcissistic. We're number one. And then we want to go in and argue in front of the jury and stuff like that. But that's not what you want to do. That's the big mistake companies make. You'll see this with companies all the time. You're not the hero. The customer is the hero. The example that Donald Miller uses that really makes this make sense is Jay-Z, right? A brilliant entrepreneur. But, he made a mistake with his music service Tidal, which probably no one has ever heard of because it was a crazy flop. But he came out with a music service, and the whole idea behind it and the marketing was essentially, we'll cut out the middleman so rich rappers and pop stars like me can make more money. Okay, who gives a shit about that? Well, okay, that's awesome. I'm going to get to this music service so Jay-Z can make more money. Nobody wants to buy that, and it flopped miserably. Instead, when we go to Amazon or we go to buy a product, what are we looking for? We are looking for a solution to our problem. I need lighting for my studio. So I go on Amazon, and I'm looking for a light that I think is going to work in here. And where do we go? When we're looking for that credibility, we go to the guide. We go to the reviews. How can we tap into that in the courtroom? Well, We're not the hero of the story. If it's a jury trial, the jury's the hero of the story. We need to cast our story, placing that jury, or if it's a bench trial, the judge, into the place of the hero. And then our case, through our witnesses and to a certain extent ourselves as attorneys, we become the guide. We are giving the hero what they need to overcome their very real problem and moral dilemma. Should we convict, or should we have this verdict in favor? What do we do? What do we do? You become the guide, and you give them the call to action, and you use some of the methodologies that he talks about. And it's not just that. I tap into a lot of experience that I've had previously in other trials and kind of other, areas of trial work. So it's not 100% about that, but the framework is there, and it's the same thing. You're selling your product to the jury, follow the framework, and it's a successful model.
See, I love that. And that tracks with, we had Rick Friedman on the podcast, very successful.
Yeah, that was an
PI
awesome
lawyer.
podcast.
And fantastic books. I mean, I have basically all of his books on my shelf. And he's like, I forgot the exact analogy, but like, does the hose feel like it needs to celebrate for moving the water from point A to point B? It's like, no, like as the lawyer, you are the tool in order to get the job done. And, he's big on removing your ego out of the situation. And that's a struggle for, I would say, most lawyers, including myself, because not only are we type A, but we're also very, very stressed. And I think in a state of stress, you go me, right? Like this defense lawyer is doing this to me, or, this other lawyer is doing that to me. This witness is, not giving me the answer, and you just want to make it all about yourself. But in reality, and I talk about this in a video that isn't released yet, but I'll just tease it. Yeah, sneak preview. Spoiler alert. The jury's going to tell you the story of the trial from beginning to end, right? Like they're not going to tell the story from your perspective. They're not going to say, well, yeah, the lawyer saw this and saw that. It's like, no, as soon as I walked into the courthouse, here's what happened. And I'm going to talk about all the characters that range from the lawyers, the witnesses, the judge, and the other jurors. And those are the people who are either going to be invested in paying attention and trying to do the right thing, not the lawyers, right? Like you said, we don't technically win cases. Facts and juries win the case. And that's something that is we got to start wrapping our head around.
Yeah. Yes. No, a lot of good points there. And that's why I kind of like this methodology, because I've believed since day one, and the first time I did college mock trial in 2004 at Western Michigan University. Let's go Broncos. Maybe someday Western may win a national title before the Lions get the Super Bowl, so that's probably never going to happen. But anyway, I remember being taught to tell a story back then and not really knowing what that meant. But just constantly working at it. What I really like about borrowing some of these ideas from Donald Miller is that it gives you a process to actually do it. So now you actually know how to tell a story. Well, how do you do that, Eric? Well, like I said, if we start with the notion that through our trial, we're going to put the jury as the hero. Like everything we do in our case is designed to give them what they need to solve their problem. And we want to give it from our perspective. So when we start thinking about it that way, it's not about us anymore. It now becomes about them. So how do we do that? Well, we do it through our guides, our witnesses. You got to prepare your witnesses. You got to put witnesses up there that are going to be credible, because if it's not a credible guide, nobody believes them. So you work at getting a credible guide. You prepare your witnesses and all this sort of thing. Then you also look at your theme and theory. How do you present this evidence to the jury? Well, theme and theory is a huge, massive, and important thing to have in a trial, because that gives clarity. And what I have found to being successful in trial is clarity. Because if you watch a movie that's cluttered and it's got a lot going on, you lose interest in it. But when there's clarity and there's focus, now we're on to something. And if you want to be successful at trial, you cannot let your opponent create confusion and chase. That's one of the big mistakes the young prosecutors do, is the defense will come up, DWI case, they start talking about the NHTSA manual and like all those things they do. And the prosecutor comes up on redirect and they spend 20 minutes just chasing every single argument they made. And I said, stop doing that. Go up on redirect and go right back into your theory. You can address those, But you're creating confusion, and you're giving credence essentially to their argument because you're just chase, and then it's all confusing at the end. You should always be guided by your theory. And I always tell attorneys one theory, not two. You don't want to get up there and say, well, this is what happened, but if you didn't believe that, then this is what happened. You got to pick one, and you got to own it. So when you think about it that way, it gives you a methodology. I'm going to develop a theme and theory. I'm going to place my jury as the hero of the story, and through my guides, my credible guides, the witnesses and the evidence, I'm going to present it, and I'm going to stay true, and I'm going to keep clarity. The other thing is, when you're really good at it, is kind of being artful with certain things like consequences to the actions. Like defense attorneys, sometimes they can outright come out and do it, say it, they're like, well, we can't just be taking away people's rights, and maybe it'll be you. They're not supposed to do that, but judges let them get away with it. You can't do it at all as a prosecutor, but through your story, you could present an image sort of like the guy, the dog. Like if there's no accountability for this, what kind of world do we live in where this guy can, and the only good dog's a dead dog? I don't want to live in that world. And you want to put your jurors into saying, this is not a world we want to live in. Find him guilty. If you're the prosecutor. If you're the defense attorney, it's the exact opposite. You now do your theme and theory to say like, well, there's consequences. You can't just be convicting people and taking away their rights. So it's both ends. But what I like about it is it gives you a methodology. You can actually plan out how to tell the story. And that's what I like, because it gives you that guide.
So it seems like there were probably I don't want to break your two theme rule, but there are almost like two core concepts going on. One is going to be simplicity or clarity, and the other one is probably even bigger than that, which is credibility. Because if you're going to be the guide and you're the one who's like, holding the jury's hand, then you want to make sure that they trust you in order for you to take them down that road and on that journey. So what are you doing in order to build credibility?
Yes, that's a good question. And I've had to learn some of those the hard way. I'll give you an example of a case. So I had a first-degree murder case, bad case. A kid, football star, I think 18 or 19, just graduated, bright future, hanging out with some of his cousins that are, not the most, best kids around, probably shouldn't be hanging out with them, and this kid he's a good kid, good grades, good student, bright future ahead, hanging out with stupid cousins. And they get in, essentially, long story short, they get into like this gang turf war over drugs, and there's a drive-by shooting. And this kid, he doesn't live this lifestyle. He doesn't know what any of this is about. And he ends up, of course, being the one to take a stray bullet and gets killed. I got 7 eyewitnesses saying this guy did it. But who are all my eyewitnesses? Every single one of them had massive character flaws, drug dealers, not working, gangbangers. They're not credible to the jury. So what your job is as an attorney, when I looked back on it, I tried to find how could I have done this better. And, as a prosecutor, you don't have time to do stuff like this, but it's the only case I ever did in my career where I actually did a mock trial. I brought in like staff members, husbands and wives to sit as a mock jury. So we ran these witnesses through, and that was the feedback we got, is like a lot of credibility issues. In fact, in the mock trial, we had one of the prosecutors pretending to be the defense attorney and telling the witnesses this is fake just to practice for the real trial. And he got so mad, I thought he was going to come up and punch our prosecutor who was pretending to be the defense attorney. And I was like, oh boy, this is going to be tough. So you have, mock trials, witness prep, especially when you have credibility issues, you got to find ways to address that. And you can try to do that through your story as well. But sometimes you get a bad hand and you just got to figure out what's the best way I can play this out, because ultimately you can't make stuff up. You're stuck with the hand you got.
But do you own it to the jury? Are you up front trying, control that narrative before anybody else can take control?
Yeah. So here's another one. Here's another hot tip. If you took one of my courses, I'm going to give it to you for free right now. I love to talk about something called drawing the sting. And if you have credibility problems, I think this can actually help get you credibility back to the jury, and it kind of lessens the blow. What's the worst thing that can happen? You have some damaging fact in your case, and you don't address it, but your opponent exploits it on cross-exam, and it's this big aha gotcha moment. Those are the worst. you know that those things are going to come into evidence. So your job in drawing the sting is to, on your case, you're not going to give them the opportunity to exploit that. You're going to bring it up first. Even if it's painful and it hurts, you can lessen the impact a little bit by you going over it quickly. If you really become a master at it, then I always refer to the Eminem 8 Mile video, the final rap battle, which I never play during the training because there's one too many cuss words in there, even for my. But as soon as I just put a picture up and everybody knows what it is. The final rap battle, how is Eminem successful? If you guys remember, he just makes fun of himself and then hands the mic over and says, here, tell these people something they don't already know about me. He wins the battle by ripping on himself and then turning it. But I know something about you. Clarence, parents have a real good marriage, right? So that's called drawing the sting. And if you're really good at it and you really work hard, sometimes what you think is a major weakness, you can actually turn around and use it against your opponent. I've been able to do that a few times, and it's a glorious moment. But things like that you have to do because especially if you're a prosecutor, you're supposed to be, and you are, a minister of justice. You don't hide things. You don't bend the truth. So if the jury thinks that you're telling them a load of crap or you're being shady as the prosecutor, you're done. You have to make sure that you stay with your story and then use techniques like drawing the sting and things like that to give your case a little bit better chance.
Totally agree. All that is fantastic advice. My only caveat for like baby lawyers who haven't gone to trial is you associate, okay, drawing the sting, any negative facts I need to address, but then you get so like paranoid about any small detail, then you start focusing on all the small things, and then the story gets convoluted. What's your advice there?
No, I think you hit the nail on the head there. It's like anything else. All these techniques that we talk about are just things to employ as part of your trial strategy, but a lot of this stuff is like using salt in a recipe. If I'm going to grill a steak, I know if I put too much salt in, it's going to ruin it. My wife's going to get mad. My father-in-law is really picky. He's going to complain, and I ruin the steak. But also, if I don't put enough salt on there, it's going to be missing something. So it's all about getting the balance on this stuff, and some of that you just learn by trial and error, by getting in and doing it. But yeah, you don't want to overdo it on things, but it's sort of a balance. It's sort of like the fear aspect. As a prosecutor, you're a minister of justice. You can't come in there and start breaking and violating the golden rule by getting the jury all worked up because, oh, look how bad this guy is and you're going to be the next. You can't do that stuff. So you got to use, it's a little bit of that gets added in as part of your general story. You don't want to overdo anything, so you got to check, because you're right. If you start getting obsessed with one area, then it can start convoluting the story, and it's always bad.
So I'm thinking out loud here, but my thought process is if the other side can't drop the mic on a bad fact, then I'm probably not concerned about it, to tie in 8 Mile and what you're talking about, to where if they're trying to blow it out of proportion, like, oh, well, the other side didn't say this, and if it's so small to where, like, as an audience, I'm hearing it. I'm like, is that really a big deal? Like, is that something that really needs to be addressed? In that scenario, you're probably okay.
It's funny too. It's kind of weird being in my role now, because I was the guy in court, ripping Marlboro Reds one after another, stressed out, hanging on to everything, and I would fall for that sort of thing too. Like, oh my God, they're going to say this. We got to go into it. But now, as an advisor, I sit back. I'm not in the trial, and I watch, and I see the attorneys getting stressed out, and I'll text them because they're like, "Oh my God, we got to talk." I was like, "Hang on, that was not a big deal. That's not the battle you want to fight right now. Let that go." And I just kick. Like, if you looked at my text messages during trial, it's almost always get back to your story. Go up on redirect and bring them back to your story. Don't chase. You're right. You get in the moment. It's easy to get caught on every single thing that your opponent's doing. And I know, because I've been there, you have to pick and choose your battles. And like you said, if it's a minor thing, don't worry about it. It's just now you're just chasing and you're creating confusion and nobody knows what's going on.
Is that harder during opening or closing, or is it harder during redirect? You hear this cross and they're trying to beat up anything and everything, and you feel like you have to fix all of it.
The hardest thing is probably redirect, and then if you're a plaintiff or a prosecutor, if you get to do a rebuttal. because the natural inclination is to come up on your redirect or your rebuttal and closing and just address all the problems. So what I teach the attorneys is redirect, bring back to you've developed a theory of this case. And I keep saying theory, guys. What am I talking about here? When you present your case, there should be a current or an underlying. What I say is I tell attorneys, ask yourself what happened, why did that happen, and why does that mean you should win? And then you create a narrative around that, and that's your theory of the case. It's like, this is what happened, this is why it happened, this is why we need to win this thing. And that carries you through. So you always come back to that on redirect, and then you poke some holes into what happened. You don't just want to come up chasing every single argument. But in my experience, yes, redirect, because some of you guys that are watching this that have done a trial or two, you know, every time there's a redirect, the opposing attorney comes up, and what do? They ask leading questions. And that's when you know that they're chasing after something, because they always do it. If you haven't done a trial, just wait. When your opponent does a redirect, they will ask leading questions, object.
What are your thoughts on objections? Are you on the ball with objections? Do you give them some slack on the other side?
Yeah, it's a little of both, because I was like an evidence nerd when I did mock trial. I prided myself on, I really dove in and tried to learn those. And I was like an evidence tutor in law school, so I'm a kind of a nerd when it comes to that. But here's the thing. In reality, in most trials, a lot of times, you don't have any judges that watch this, do you?
Who knows? I have no idea.
A lot of times, sometimes the judges, guess what, guys? They don't get it right. And that can be frustrating as well, too, especially if you really know the rules of evidence well. So I say be tactical about it. I let my opponents get a lot of stuff in that's probably objectionable, but you got to know your audience and the feel. A lot of times I'm not going to object because it's not hurting me. It's some minor thing. And if I just keep standing up objecting, at what point does the jury think that I'm trying to hide something from them? So it's all about tactics. Don't object just because it's an objection. Think about how it plays into the bigger role of your story. And obviously, like, I'm not going to let the opponent do things like blatantly. You know, for example, as a prosecutor, if you want to get a self-defense instruction in, you got to put your client on the stand. And that's what I want, your client on the stand, so I can cross him. So I am not letting you get any movement on hearsay statements or anything else. You want to do that, you're going to have to put him up there, because that's a tactic move. But other stuff, you know, they get a couple of hearsay things in there. I'm not worried about it. It's not moving the needle, and I'm sitting back like it's no big deal, and it's not affecting my story anyway.
So I blame mock trial for like my desire to object and win the objection, because you get points off of that, right? Like you get scored on that. But if we tie back into the story brand concept that you're preaching here, it's not about me, right? Like the trial isn't about me having those small wins. It's the perspective of the jury and the story they're seeing unfold in front of them. And like you're saying, like, is the story that they're seeing unfold in front of them look like their guide is either on the defense or their guide is trying to hide something and is losing credibility, and the optics of it may not be worth the battle or the struggle.
And it depends on your jurisdiction too. Like if you are a prosecutor, you can file motions ahead of time. It just depends. It's very chaotic out here in New Mexico still. And we have so many trials that a lot of times it's truly, you know, there's no time to file the motions ahead of time. But if you're in a jurisdiction that doesn't do as many, file those motions ahead of time and take care of it, so you don't got to worry about that in the trial. I'm actually encouraging our attorneys to do more of that now, especially on bigger stuff. You know, I'm like, you guys should...
Easy for you to say it now, huh?
Yeah, exactly. I'm like, well, yeah, if you have time. But I tell them, like, file that motion. If you got some important 404B thing that's kind of complex, let's file a motion ahead of time and make the arguments. And that way, if we feel like the judge got it wrong or wasn't understanding the argument, we at least have the opportunity to appeal it if we want. And then you don't want the trial to be about that. You want it to stay focused on the story, and objection after objection just turns it into a circus. And it's not a good thing. Even if you're a defense attorney, which confusion is helpful, I still think that's like a chaotic way to win. The best defense attorneys that I went against had sort of controlled confusion. They would create confusion towards my story, but then they would create clarity on their own. That's when you're really good.
Just go down like a reasonable alternative.
Yeah, they would
in order
essentially
to-
they would create confusion with all this stuff, but they had this undertone of like, this is what really happened, and they would stick with it. And that's like the really good ones would do that. The ones I could tell that, you know, hair on fire was just create as much confusion as possible, and that is still a tactic, but it's not the best tactic. I don't think you're really playing with fire there.
So walk me through strategy with closing argument then. If we're going to empower the jury, make them the hero, how do we motivate? How do we get them on the same page that we want them to be on?
Good point. Well, it starts in your opening. There's, you know, Jerry Spence and a lot of good attorneys, they swear that opening is the most important part of the trial. I've went back and forth over that over the years. I still believe that opening is probably a little more important than closing because you establish your theory and your story right away. And I think a lot of times the jury's probably made up their mind before you even get to closing. But a great closing argument you just kind of seal the deal, and you feel good about it if you nail it. And what you're trying to do in the closing here is you're taking everything that you promised in the opening statement, and then you're just telling your story to the jury. But now you get to argue it a little bit more. And again, you stay focused on the things that matter. So we want the jury to see things like, here's the evidence we presented. And within that, they see some consequences. You know, when we use loaded terms like murdered buddy, we start to create like you got to have accountability if you're gonna shoot the neighbor's dog. This is not one of those crimes that we can no big deal. It's a ticky-tack thing. You know, a lot of times I see prosecutors, they'll take a case to trial that probably should have been screened out. You know, it's kind of a ticky-tack charge or something. And juries, they're like, why are you wasting our time? They get rid of it. When you got something like that, you got to make, especially if they might think like this is a serious charge, but they're not going to think so. You got to make sure you're arguing those points in closing that come back to your story, giving them a reason why. I always say that, give the jury a reason to want to be on your side. That's what you're trying to tap into in closing, is just get them fired up for the final push.
And what are you doing whenever you're now sitting down, hearing the other side give their closing argument? Are you trying to figure out, okay, how can I flip themes? Or are you trying to stay with your theme? Or are you just trying to just have a couple counterpoints instead of chasing and going down rabbit holes? Like where's your head at on that preparation?
Yeah, that's tough because everything they say, you're just writing notes saying bullshit. They didn't say it's not what that said. So you got to pick your battles here. So you're listening. I try to okay, I'm not going to write a note for everything. Listen for the main points. And then I've already prepared my rebuttal. It's canned. I have a PowerPoint ready to go. So I don't care what they say. My rebuttal has been rehearsed, and I'm going to come up and start my rebuttal the way that I plan to, which is going right back into my story. It's kind of like this. You're getting up there saying, all right, let's come back from Fantasy Island. Look, what I've been telling you all day is that this is a guy, took a gun, took a life, took off. This is what happened. I go through my favorite facts, and then I'll poke some holes, and I'll pick the top 3 things that they said that I think I can poke holes in, and I'll just focus on that. And then I come right back to my strong point and end strong. So I'm taking notes on what they say, but a lot of times, probably 80% of the notes I wrote down, I'm not even going to address it because then you're just chasing arguments and creating confusion. Just pick the top 3 things and then always start with going right back to your theme and theory, your stuff. Then you poke a few holes, then you end strong back on your stuff again.
I have to ask, are you animated when you're on the sidelines? Like you hear the other side say or do something that you just don't agree with? Are you shaking your head, making a face, or are you just as statue-like as possible?
I've been a prosecutor my whole career, so every trial I've done has been as a prosecutor. So I realized, I especially learned this later on, the jury's watching you. They have an idea of a prosecutor, and I want to fit that. I will never take a case, or I'll never put a win or something above my ethical duty as a prosecutor. I have dismissed a lot of cases against guys that were guilty as sin, but there were constitutional issues. Maybe an officer violated one of their civil rights, or there was just I know this happened, but this is not a credible witness, got to get rid of him and dismiss it. So I've tried to work really hard about not being a bad prosecutor and making faces and stuff like that, but it is hard sometimes, especially when I was getting burnt out towards the end. I'll tell you, I think this was maybe the second to last trial I did as a prosecutor. It's like 2018. I'm already burnt to a crisp. Like, I got this kid on the stand, and he's just up there lying his ass off because he's scared of the defendant. So we take a recess, and I essentially get this kid out in the hallway, and I'm just lighting into him. I'm like, if you don't get up there, start telling the truth right now, I'm charging you with perjury. I was like, tell the truth. So here I am yelling at this poor kid, and I was like thinking, like, man, I don't know how much longer I can keep this up. But he did go up there and tell the truth finally. Of course, that case was in such trouble that was an easy not guilty. When you're yelling at your witnesses in the hallway, it's never a good thing. But yeah, I think towards the end, that was just a sign of some of the burnout that I was going through. You really got to manage your expectations. Looking back on it, a proper thing would have probably let another attorney go back and play his, pre-trial testimony and say, look, this is what you testified to before. We know the defendant's scaring you, but you got to tell the truth, stuff like that. So yeah. And I do know some other prosecutors. I work with a couple right now that I got to remind them, they wear their emotions on their sleeve. The defense attorney will do something dumb and make an objection, and they kind of roll their eyes, and the juries are looking at that stuff, and they've made comments about it before. So you got to be careful. You're being watched. Also, if you are a prosecutor, keep in mind, like, there's expectations of you. And I think as a defense attorney too, like, especially depending on where you're at, being an attorney is still a noble profession. I know some people probably disagree with that, but you don't want to be the cliche, dirtbag attorney in there. That gives the whole profession a bad name. So I always try to be as professional as possible, be my advice.
So counterpoint to that, which I don't feel strongly about, but there is something about adding that entertainment value that keeps them engaged instead of just being as stoic as possible. Granted, I don't have the confidence to be like animated to the nth degree of like, and throw my hands up and just be dramatic like that. But my eyebrows get dramatic real fast. Like, I'll just, like, something happens and my eyebrows aren't real happy about it. And so I have to be kind of self-conscious and aware, but I also don't know how that plays in front of the jury, because I'm thinking along what you're saying is, if I'm the more credible one and I'm starting to scratch my head, is the jury starting to think, oh, well, something must be up because the guy who we're starting to trust here is starting to scratch their head. I don't know what the answer is to that. Like, I don't know if you have thoughts on it.
Yeah, well, what you're saying reminds me of, this is something I wanted to mention. If you are a young attorney, maybe you've done a trial or two, and you're kind of watching this saying, like, what are some big takeaways I can take away from this? I would say, to your point, one of the biggest lessons that I learned early on is that you as an attorney, you got to find a style that's you. So when I did mock trial in college, I was all about Jerry Spence, and I started watching these Jerry Spence videos. This was in law school, actually, when I had already, I'd won awards in college, and I had pretty good, I kind of had my style. But I don't know, I got on this big Jerry Spence kick, and it was like a regional tournament. I basically came in, and I was Jerry Spence reincarnated. Every argument, facial expression, and it was terrible. My coach is like, what in the hell are you doing out there? And I realized, like, you can't just go and copy somebody. You have to be yourself. And you got to find a style that works for you. Some people are really good at fire and brimstone, man. They come in there yelling, and it works for them. They got a way to control it where it's entertaining, it's dramatic. Other people, like myself, a lot of comments that I got in mock trial to get better was, they called me a steady Eddie. Like, you are right on the ball, but there's no animation there. So I really worked on, in doing trials, more of being a little more animated and more theatric, and that's where your story can come in. But also things like, if you're lucky enough where you can move about the well of the court, don't stand at the podium if you can get away from it, if you got a microphone or something like that. I used to get so intentional that I would move when certain points were made, or move with a timeline. So things like that. But most importantly, find a style that's you. You can look to other attorneys. Like I would look to Jerry Spence now and say, okay, Jerry Spence is great at telling a story. That's what you want to take away, but you don't want to go copycat. You got to find examples of attorneys that you like. You can emulate that idea of what they're doing, but you got to stay true to who you are and what you do. If you're not a yelling kind of guy, don't come in there doing that's going to look ridiculous. Same thing if you're very animated and you try to be really quiet, that's probably going to look weird too.
It's funny you say that. So in law school, we had a mock trial final round, and I won't put the guy on blast, but his mom was a judge who came in to watch, and I can't remember the specifics, but I think she was sitting near me, and this her son's doing a opening statement or a closing argument, and he is just thick with the twang. Like the twang's coming out. Going to school in Texas Tech, we're in Lubbock, and everyone that's training us, teaching us, all these lawyers coming in, they all have that like twang. His mom, like, and almost like loud enough for everyone to hear, leans over and goes, "He's never had twang for a second in his life. What is that?" And it was honestly like, and he had no idea. We like joked about it afterwards. He's like, "I don't know where that came from, other than watching all these people who have been influences, and that kind of being home base, and him not necessarily being true to himself." But it was almost subconscious to him. Like he didn't realize he was doing that. And along those lines, because especially early on with anything you do in life, you always want to imitate the people you idol or the people who are coaching you, mentors, because that's just the easiest thing to do until you figure out your style. But I will say it's such a relief, and it makes you such a better advocate, lawyer, whenever you do find your style, because you're no longer having to think about being someone else, and then you're just in the moment, right? You're in that flow state of like, this is me, this is my style, I'm confident in that style, and this is just how I'm gonna rock at that point in time. Versus like maybe what you're thinking, like Jerry Spence at this point will do this or do that, or this is how he would be in that moment, and you just spend so much energy like freezing up and becoming hyper focused on things that you probably don't need to be hyper focused on.
Yeah, no, I was him, man. I was moving to a ranch in Wyoming. I was so Jerry Spence at that point, and it was a disaster. I had to snap out of it.
That is so funny. That is so funny. All right, Eric, we've gone through a lot, and I don't want to just
believe
like
it's been an hour. Jeez.
Yeah, I don't want to blow people's minds by overwhelming them to where it's like drinking water out of a fire hydrant. So let's wrap it up with this. How are you doing? Do you think about the Lions during this last hour?
No, it's great. I feel pretty good. Fired up. I actually, I put in a full day of work today, and I was like, man, I got a couple of things I got to knock out, and now I feel a little more energized to do it. It's also, I need to record some more videos. Now I got the dust off of everything in here. We had a massive case come out, New Mexico state law, and as you can see, most of what I do on my podcast is educating law enforcement when there's changes in the law, and this is such a huge case, and I'm like, man, it's been a week, I gotta record something, so I might actually sit down tonight and just record it, because I haven't put out a podcast on my channel in a while, and I need to get it done.
Okay, so we've talked about the Lions' loss, though. You have a big win in your life. Someone is a DAD these days.
Yeah, so that's an interesting thing. Becoming a dad at 40 was not the original game plan, but it's been a wild adventure. The funny thing is, so I had spent almost 4 years preparing to start this business venture that I'm on, and I had literally put my 2 weeks notice in, and about 15 minutes later, my wife called me and said, got to tell you something. And she was in a bit of shock too.
That is life.
Yeah.
That is life.
So we decided
right
to do it, and it has not been easy, but it's been fun, and I wouldn't change anything, and it's working. So I feel
Dude, I'm
blessed.
proud of you, man. Yeah. We just got to get you on Law Venture more often. So I'm going to have to keep like stealing you away from your businesses, your family, your lions, and
We need
that way
more.
we can keep pumping you for content.
Yeah, we need to do some more videos.
If you're not burning out on videos, I'm not doing it right. That's what I've learned.
I know. I miss those videos too. The cross examination one was such a fun one to do, and I have so many other little topics. I mean, there's so many things today that we talked about. I could easily do a 15-minute video on step 1, going through the jury instruction and how you prep that. So there's so much stuff to do.
I'm assuming people are probably dropping off at this point, but if there is something you want Erik to talk about, let's peer pressure him down in the comment section, and that way we can start getting more content from him. But Erik, I'm going to let you go. I appreciate it. For those watching, I appreciate you for watching. Hit the like button. If you're not subscribed, you know the drill. If you have any questions, comments, concerns, thoughts, comment section down below. We'll see you in the next one.